Well, good morning. Welcome, everyone. And I just want to introduce myself first. Sherry DeNovo. I'm the Member of Provincial Parliament for Parkdale High Park. In my Parkdale part of the riding, 90% of our residents are tenants. And as many of you are aware, it's very difficult to be a tenant these days in downtown Toronto. Rents are extremely expensive. There used to be a rule of thumb that only 25% of your income should be going to rent. Clearly, that's not the case anymore. In the light of all of this, we in the Ontario New Democratic Party over the years have introduced a number of bills to try to affect the ground for tenants, to make it easier to be a tenant in Toronto and more affordable. Of course, rent control has been on the docket many times over the years. We also, through Peter Tabuns, introduced a bill this last year around the 1991 loophole. The government finally responded with a bill which addressed some of these issues. There's a big problem, though, and that is that many of the conditions set forward in this bill don't come into play right away. There is a lag time. So what has happened, and Percy Hatfield, who is our housing critic, will go into this in some detail. What has happened is that landlords are taking advantage of that loophole. Landlords, knowing that the laws are going to be changing, are jumping in, raising rents, charging for hydro, moving their family in without compensation to tenants, asking tenants to leave, all of the various aspects of this bill, but they're doing it now because they've been given heads up. Clearly, this is unfair. Clearly, this is not what we've been fighting for all these many years. And you're going to be hearing from two tenants who have direct experience of how difficult this market can be and how difficult the implementation lag of this new law will make their lives. So without further ado, I'm going to turn it over to Percy Hatfield, our housing critic, and then we'll hear from our two tenants, both of which happen to live in Parkdale High Park. So welcome all.
Thank you, Sherry. Yes, we're going to be hearing from Helen Dvorak, who is a tenant, and Aaron Benson as well. I think it's pretty common knowledge that when this bill came into effect, the Liberals got the headlines, but now the tenants continue to get the headaches. I tried at committee to amend the bylaw, or to amend the law so it would come into force immediately, but the Liberals voted it down. In doing so, they gave landlords a huge loophole to skirt the intent of the legislation. Instead of looking after the tenants, the Liberals are actually making the rental housing situation worse for tenants. Many tenants have been abandoned by the Liberals. Landlords have stepped up their evictions, supposedly for their own personal use. They're still raising the rents before the bill comes into law. There was no need for this. We in the NDP supported the bill. It was passed at the end of May, but the Liberals still haven't finalized it. Tenants should be entitled to compensation if the landlord kicks them out so the unit can be used for themselves or for members of their family. Elevators should be repaired before the rents can be increased above the guidelines. There was no good reason not to implement all the provisions when the bill was passed. By stopping the law before being put into action now, or from being put into action now, I should say, Kathleen Wynne and the Liberal government are actually making things worse for the tenants. With the rental market as expensive as it is, especially in Toronto, tenants literally cannot afford to wait for these protections to be implemented. This ridiculous delay is benefiting landlords that would take advantage of the situation and hurting tenants. Once again, it is so obvious whose side Premier Wynne and the Liberals are on, their friends, the landlords. She must undo the harm she's done and bring these protections into force immediately. And then we need to talk about the next steps to make sure tenants finally get the protection all families deserve. There is nothing fair about the so-called Rental Fairness Act. Tenants continue to be victimized by their landlords. The sad situation is that the Liberals say these sections may not have been proclaimed or may not even be proclaimed until sometime late this year. And you know as well as I know, if this delay continues, these sections may not be proclaimed at all before the next election. The Attorney General's ministry says the Landlord-Tenant Board requires up to 12 months before the amendments come into force. Give me a break. How much time does the LTB need in order to not process an above-guideline application for a hydro bill increase, or to order an elevator be repaired before an AGI application is approved? We expect landlords to ramp up evictions and above-guideline rent increases as the Wynne Liberals continue with this delay. We all know there's a crisis in affordable housing in Ontario, right across. We need a government that takes affordable housing seriously. We're here today to call on the Premier to do the right thing. People are worried the Liberals were credited with progressive legislation. This is anything but. It's a dog whistle to the landlords. Last chance, folks. Zing your tenants now. Kick them out. Raise your rents. You have a year or less to get it done. So we're going to turn it over to Helen and Aaron. And they are tenants. They both have stories to tell. And I'll ask Helen to lead it off.
Thank you. I'm a tenant in the High Park area currently. On May 7th, I was served with Form N12 by my landlord. The Form N12 is a notice to end my tenancy at the end of the lease term because the landlord plans to use the property for himself or his own family. Although I don't have any reason or any proof to suspect that my landlord is doing this in bad faith, my issue with the Rental Fairness Act is that the provision dealing with N12s is not retroactive. So the Rental Fairness Act should be protecting the tenants' rights and trying to mitigate the power imbalance between landlords and tenants. However, because it's not retroactive, it's just encouraging landlords to take advantage of these loopholes while they still can. So my problem is that I believed I would be entitled to compensation 1 month's rent after being served a Form N12. However, after writing to my MPP and learning that this legislation is not in fact retroactive, it was disappointing, and I do feel that there's going to be an influx of tenants who are now looking for new rental units, and this will just make the renting market in Toronto even more difficult for tenants and give landlords even more power.
Thank you. Aaron?
I couldn't agree more, Helen and Percy. Thank you. The law became law, achieving royal assent on the 30th. I received notice on the 31st, but yet these provisions provide this loophole or an extension that is indefinite. I spoke to the LTB. The LTB simply is waiting for instruction. So there's no hesitation required on enacting the simple deliver an N12 because you would like to break a contract. So pay the penalty to break a contract as anyone would in any other circumstance. And I couldn't agree more that there's a rush on in our neighborhood. Parkdale is having a rent strike currently. There are people who are being thrown out, and there are people who are much less able or capable than Sam and I to be able to find a place to move where they may have been there for ages, and they're being pushed out now with a 50-60% increase in rent and 1 month to make good on a first and last.
The Liberals did nothing for 14 years. They ignored the calls from the tenants groups for 14 years. And then all of a sudden, Peter Tabuns introduces a bill on getting rid of the double standard in rent control. And the Liberals tripped over themselves to get a bill on the table. That bill was so rushed. At committee, there were 123 amendments proposed, and 48 of them came from the Liberals themselves. In the NDP, we only had 46. The Liberals had 48. And they still can't get it right. They should be embarrassed. They should apologize to the tenants, and they should make things right before this week is over. There shouldn't be any excuse. They messed it up, and now it's time to set it straight, and we are open for questions.
You want a solution by the end of the week? Is that fair?
Well, I'd like a solution today if I could get it, John. I mean, tenants are going to be victimized again and again unless the Liberals send out a signal very clearly to the Landlord and Tenant Board. Do what the intent is there in the bill. We may have some paperwork to tidy up, but the intent. This is coming down. Start implementing it now.
And you heard from Aaron, the landlord and tenant board. I mean, how much time does it really take to do new forms, really? This is a pathetic excuse for not moving on this bill. And Aaron also pointed out we have a rent strike on the go in Parkdale. Is this really what the government would like to see spread across the city? Because when people have their backs against the wall, there's nothing much left to them in their toolbox. And again, this holds out hope, but in fact doesn't deliver on any of it and makes the situation currently much worse.
Sure, you mentioned that form, so is it a bureaucratic delay?
Well, what you heard from Percy talking about the Attorney General saying it's going to take them 12 months. 12 months to change their modus operandi. This is absurd. It's an excuse. There's no reason, like any other bill or any other piece of legislation, that it couldn't come into effect right away, and that this couldn't become the law right away. There's no reason to give the landlords this much lead time.
Is there any idea of how many people are affected by this? I mean, how many people are being evicted from their homes as a result of these changes, or I guess as an indirect result of these changes?
I don't have a complete number. I think it's the tenants groups, the various ones in Toronto, for example, may be able to give you better numbers. That's normally where the tenants go with their complaint. But then we hear within our constituency offices from other people. So it's tough to say at this point, but
Dozens of people, you think, or is it hundreds of people?
I don't want to put a number on it. Sherry may be in a better position for that.
Parkdale Legal is an organization in our area that might be able to help you with that. But I can tell you anecdotally, not only Aaron and Helen, but also a staffer in my own office has been affected by this. So anecdotally, since this has happened, we've heard from a number in our own office, and that again is just the tip of the iceberg, and that's, again, that's on top of the currently pretty awful situation for tenants in the city right now, with above guideline increase asks by landlords right across the board, and again a rent strike, 200 tenants, and that was before this loophole was put forward. So they made a bad situation much, much worse instead of better.
It doesn't take forms to compensate the tenant for breaking a lease, and there's no reason why some of these provisions couldn't be enforced instantly. The law achieved royal assent, and that's the beginning of the stopwatch for when you can start evicting people. Instead of this becoming the law of the land, and this is what should benefit tenants, it actually is take as much as you can from them.
Can you tell us a little bit about your rental situation, like one bedroom, and exactly what you heard from your landlord? Did he serve you the N12 notice, or was it in an email, or how did it come about?
I was served the N12 notice properly, the printed off form from Landlord and Tenant Board website. I currently occupy the third floor of an Edwardian house in High Park. The house is split into units. My landlord owns two houses, and he and his family live on one floor of one of the houses. So his claim is that he plans to convert one of the houses back into a single-family dwelling for himself and his family.
Helen knows of which she speaks. She works on issues such like this every day, right?
Yes, I'm a legal assistant to a lawyer who specializes in residential tenancies. Most of our clients are large corporate landlords.
So did you get any kind of compensation, or you just get a notice saying you have to, you're being evicted effectively?
Well,
on
under
some
the
date?
current law, tenants who are served with Form N12s are not entitled to any compensation, and there's no remedy, really. There's no way that the tenants can fight this. The only remedy that tenants have is if they can prove up to 1 year later that the landlord was serving the notice in bad faith and that they did rent out the unit again at a higher price. However, this is a year later, and it's on the tenants to go after this and pursue this issue themselves. Meanwhile, they've already had to find a new place to live. They've already suffered financial hardships because of this. And the provision in the Rental Fairness Act dealing with N12s, it's to prevent, or to try to prevent, landlords from taking advantage of N12s by ordering them to pay tenants 1 month's compensation. So the purpose of this is to prevent them from taking advantage of this, but however, because this provision is not retroactive, there's no current right that tenants have to compensation.
Do you think you'll follow it through, will you, I mean, you're basically being asked to play detective to see if the family member moves in. Is that something you plan to pursue, or are you just going to find a new place and move on?
Well, there's no choice that I have. I have to move on. If I do see the unit listed again at a higher rent, or for rent at all online, then I'll definitely be following up with a tenant application. I have no reason not to. However, I'm not counting on getting any kind of compensation, and I'm not planning on trying to extend my tenancy because there really is no legal remedy for the situation.
See, this is a loophole that the Liberals took credit for trying to solve when the bill was introduced. Because of the rapid escalation in rents, especially in Toronto, landlords were evicting people saying it's going to be for my own use. So the Liberals come up and say, if you don't do it, you're going to have to compensate the tenants, which is good. Everybody's in favor of that. But now by delaying the implementation of the bill, the tenants are still getting screwed, and the landlords are now saying, okay, we have a loophole, we better get out there and start evicting more people. And until they close the loophole, tenants are really going to get it again.
And you can imagine that, you know, someone who maybe doesn't have English as a first language is on social assistance, which many of our tenants are in South Parkdale. Their first order of business is to find another home. It's not to go after and play detective for a landlord. They need the law to protect them. You know, going to the landlord and tenant board or tribunal, that's a pretty scary aspect, you know, for a lot of people who are tenants, and especially when they're up against landlords, often with lawyers in tow. So again, we need protection for tenants, and this bill is clearly not going to provide that for some time, and in not doing so is actually providing protection for landlords instead.
And we've all heard about the problems with elevators. You guys have written about the problems with elevators not being repaired, and then the owner comes in and says, I need a rent increase to pay for the maintenance of this. And you know, the intent of the bill was, okay, fix your elevator before you get above guideline rent increases. Now they don't have to do that until they close this loophole, until they make it law.
There was a building in South Parkdale that was 8 stories. There were seniors living on the top of that 8-story building. The elevator was out of service for months. Many of them, as you can imagine, couldn't get groceries except through the kindness of strangers often up to their floor. This is not an uncommon story. We've had many stories like this. Again, Parkdale Legal's files are full of them. This really is unconscionable.
It's
What's your situation? Are you in a high-rise or a
No, it's a detached home in Parkdale. I'm on the second and third floor. I share with a couple of roommates, and our landlord is living on the main currently, but he would like to take our unit for himself and his family.
So he actually lives in the same. Okay.
He does, yeah. Yeah, and again, much as with Helen, I think I was served properly. This is, you know, to your question as well, this is a hill that no tenant can afford to die on, right? That you're not able to both find the resources to make first and last on your next place and make a move quickly, but then also to then chase the landlord. So the intention of this law is to shift the onus back onto the landlord for the responsibility of breaking a lease agreement. This is a shotgun clause that's been used and abused for years, and you know, so take some responsibility for breaking a lease. You know, pay your tenant some compensation and say, you know, what you're going to do clearly, and then the onus is on you.
I think in Aaron's case, and Aaron can explain it, he got one notice saying the mother-in-law was going to move in, and then plans changed. He got another notice saying that the main family was going to shift it around. You might want to clarify that.
That's true. I was served the day after the law achieved royal assent, and then I think in discussions with my landlord, who, you know, in fairness, has been out of country. I'm sure he wasn't aware of the particular legal shift, but you know, upon discussion, I think that he decided that it was appropriate to be a little bit more clear in his plan. So the intention changed, and I was served again, and I think properly, and I have the appropriate amount of notice, and you know, we have resources and ability to, you know, work and, you know, find another place. But there's a lot of people who will be facing 50 and 60% rent increases. You know, they have to work double time now.
How long have you guys lived in your?
I've been in my unit for 2.5 years.
I was only in my rental unit for 6 months when I was served the Form N12, and I was served the Form.
Full year lease. Sorry, you'd signed a full year lease then?
I had an 8-month lease. And so the Form N12 was terminating my tenancy at the end of the 8-month lease. And after the lease term is over, how it usually works is tenants will go on automatically on a month-to-month basis. And I was under the understanding when I signed the tenancy agreement that's what the situation would be like. So to find out suddenly that my landlord was going to be converting the house back into a single-family dwelling after so many renovations had just been done before I moved in was pretty shocking, and I did not see it coming at all.
In fact, did the landlord give you an indication you could be there as long as you wanted when you first moved in?
Oh yes, I was told that I could continue my tenancy on a month-to-month basis as long as I wanted.
Thank you all.
Thank you.
Thank you for coming in.
And thank you for inviting me.
Thanks
thanks for having us.
Thank you.